Hello everyone, Drishti IAS welcomes you to the new series of To The Point. Today's topic of discussion is Habeas Corpus. First of all, let's see why is it in the news. Recently, the Supreme Court decided to examine a habeas corpus plea made by a children of Pakistani national who they believe has been unlawfully detained for 7 years. Now let's understand what is habeas corpus. It is a Latin term which literally means to have the body of. Under this, the court issues an order to a person who has detained another person to produce the body of the latter before it. The court then examines the cause and legality of detention. This writ is a bulwark of individual liberty against arbitrary detention. The writ of habeas corpus can be issued against both public authorities as well as private individuals. The writ, on the other hand, is not issued where the detention is lawful. The proceeding is for contempt of legislator or a court. Detention is by a competent court and detention is outside the jurisdiction of the court. Now let's discuss about Article 32. Article 32, right to constitutional remedies, is a fundamental right. It states that individuals have the right to approach the Supreme Court seeking enforcement of other fundamental rights recognized by the Constitution. The SC has power to issue directions or orders or writs for the enforcement of any of the fundamental rights. The writs issued may include habeas corpus, mandamus prohibition, certiorari, and quo warranto. Now discussing about the writs. The court can issue various special orders known as writs. Habeas corpus, mandamus. This writ is issued when the court finds that a particular office holder is not doing legal duty and thereby is infringing on the right of an individual. Prohibition. This writ is issued by a higher court, high court or Supreme Court when a lower court has considered a case going beyond its jurisdiction. Quo warranto. If the court finds that a person is holding office but is not entitled to hold that office, it issues the writ of quo warranto and restricts that person from acting as an office holder. Certiorari. Under this writ, the court orders a lower court or another authority to transfer a matter pending before it to the higher authority or court. Now let's discuss about Article 226 of the Constitution. Article 226 of the Constitution empowers a high court to issue writs including habeas corpus, mandamus, certiorari, prohibition, and quo warranto for the enforcement of the fundamental rights of the citizens and for any other purpose. The phrase "for any other purpose" refers to the enforcement of an ordinary legal right. This implies that the writ jurisdiction of the High Court is wider than that of the SC. This is because the SC can issue writs only for the enforcement of fundamental rights and not for any other purpose. That is, it does not extend to a case where the breach of an ordinary legal right is alleged. The High Court can issue writs to any person, authority, and government not only within its territorial jurisdiction but also outside its territorial jurisdiction if the cause of action arises within its territorial jurisdiction. Now it's time for the practice question. Consider the following statements. 1. Habeas corpus is a bulwark of individual liberty against arbitrary detention. 2. The High Court can issue writs to any person, authority, and government only within its territorial jurisdiction. 3. The Supreme Court can issue writs only for the enforcement of fundamental rights and not for any other purpose. Which of the above statement or statements is or are correct? 1 only, 1 and 3 only, 2 only, or 2 and 3 only? Send the answer of this question in the comment section. Stay tuned for the next episode. Thanks for watching. Have a great day. Dear viewers, watch this topic in Hindi on our Drishti IAS Hindi YouTube channel.